to wind up the debate on behalf of the Public Petitions Committee. Mr Brodie, you have until 5 o'clock.
Thank you, Presiding Officer. As anticipated, I think this has been an interesting, even necessary debate, as Joan McAlpine pointed out. Now, let me make it clear, Presiding Officer, that the intent, I believe, of the petition, and indeed the debate, was and is not to impugn the independence, the integrity or the credibility of the judiciary at large. In fact, the very opposite in some of the statements in the debate today, contributions from across the chamber, all addressing the words of openness, transparency, perception, clarity, trust, the need to change. All of these embrace, I think, some of the concerns that we on the Petitions Committee had. The debate, of course, as everyone said, is rooted in the petition raised by Peter Cherby in terms of the Register of Interests. And, of course, it did call for a pecuniary Register of Interests, although it did also suggest an amendment to legislation to submit general interests and also hospitality. Now, it's perhaps instructive, Presiding Officer, to consider the history of the current position vis-à-vis the Register or indeed the production of documents to the Parliament. Section 23(7) of the 1998 Scotland Act stated that the Scottish Parliament may not impose a requirement to give evidence or, importantly, produce documents on a judge of any court. But when one looks at Hansard of the time, there seems to have been little debate of the general rationale behind judiciary exemption in that debate, except for the current Advocate General, who suggested it should have been, he did at the time, suggested it should have been incumbent upon anyone to attend and compel witnesses to attend and to produce documents. The relevance was that the provision be made to protect the judiciary's position in the Constitution, that the impartiality of the judiciary in Scotland would be secured, and that in the event of a potential conflict of his or her interests with the circumstances of a case, a judge would necessarily recuse himself or herself from said case. That, of course, relies on the determination of a judge's relevant interest by the judge himself, but that tends to cover all relationships, as the Minister intended to, whereas primarily we were talking about monetary and hospitality considerations. There are, of course, some safeguards to ensure, as we have mentioned, the impartiality of the judiciary, which might mitigate and temper suggestions of impropriety by members of the judiciary because of a lack of transparency regarding their interests, particularly those of a pecuniary nature. We have mentioned the judicial oath, where the judges swear that they will do right to all manner of people without fear or favour. There, of course, is the Judiciary and Courts Act, which sets out the rules which may be invoked if it is felt a holder of judicial office is not acting impartially. And Section 28 of that Act allows the Lord President to make rules for the investigation and complaints about the judiciary, a matter to which I hope briefly to return before 5 o'clock. Thirdly, Presiding Officer, there is the Statement of Principles of Judicial Ethics for the Scottish Judiciary, revised in May 2013, which is to be used as a guidance of holders of judicial office in Scotland. But enshrined in that document is perhaps the basis of the petition and the basis of an understandable perception or indeed misperception, which underpins the petition and rises and gives cause to concern. Section 4.9 of that Act states, and I quote, "However, it is recognised that a judge may, from time to time, legitimately be entertained by legal professional or public organisations or office holders in furtherance of good relations between them and the judiciary as a whole, or representatives of it." What on earth does that mean? It then goes on, "Furthermore, nothing said here should be understood as inhibiting judges from accepting invitations to give lectures, addresses or speeches of a non-legal nature at dinners or other occasions, or from accepting hospitality, tokens of appreciation for their efforts, or appropriate expenses of travel and accommodation." And that in itself is okay, but I know openness and transparency of information would eliminate some of the misperceptions that matter. Presiding Officer, in addition to these safeguards, we have mentioned the Council of Europe group, the Greco, which stated that it found no element of corruption against judges, but one might argue that that was not the charge. Rather, that a register might secure the transparency that would make their evaluations redundant. Presiding Officer, the petition raises several questions, none of which I would suggest requires a defensive posture. For example, the Scottish Court Service. The annual report notes that the officers and the board, of which 3 members are judges, already declare some interests in the annual report. We also understand that the SCS staff are required to register all of their interests, and I fail to understand why that cannot be extended to cover the whole of the judiciary. And secondly, Presiding Officer, the Judiciary and Courts Act set up the role of the Judicial Complaints Reviewer. And that role is set to review the handling of investigations into the conduct of the judiciary. Now, the previous holder of that role, a role which I suggest should be much more robust and recognised as very important, indicated that in the interest of general transparency, a register of interests of judiciary would likely lead to an increase in public confidence and trust, 2 of the words I mentioned at the very beginning. And of course that also extends not just to the SCS, but to the Crown Office and the Procurator Fiscal Service, who operate a register of hospitality interests, and the Scottish Legal Complaints Commission, which publishes a full register of interests of hospitality and interests. Presiding Officer, we accept that the petition called for a register of pecuniary interests, that it recognised that we would need to try and capture not all of the other concerns that might arise, as the Minister said, for example, family relationships, and so we accept that in practical terms it might be impossible to capture all interests that might arise or cause concern. The onus should rightly be on the judge or the sheriff to declare any relationship interest at the beginning of such a case and to recuse appropriately if necessary. And lastly, Presiding Officer, there is the concern that such a register would have unintended consequences, a phrase which has been used often today, for the judiciary's freedom and privacy, or freedom from harassment from the media or dissatisfied litigants. These are concerns, but they are no less so for others, including MPs and MSPs and others in public life, who may be attacked publicly for non-declaration of interests. While it is argued that the establishment of such a register may have these unintended consequences of eroding public confidence in the judiciary, it might equally be argued that its absence may have that very effect. So lastly, Presiding Officer, may I congratulate Peter Cherby, the petitioner. May I welcome the exchange that we had with the Lord President, although I had wished to be in front of all of the committee on this particular issue. This issue, which I suspect will still be a topic for review and will be, as Stuart Stevenson said, recalibrated, and perhaps the snub to the Scottish people will be recovered. And I am glad that we have had the opportunity to discuss and debate this in a meaningful way today. Thank you.
Thank you, Mr Brodie. That concludes the Public Petitions Committee debate on petition number PE1458, Register of Interest for Members of Scotland's Judiciary. We now move on to decision time. There is one question to be put, and that is the question is that motion number 11078 in the name of David Stewart on petition number PE1458, Register of Interest for Members of Scotland's Judiciary, be agreed to. Are we all agreed? The motion is therefore agreed to. I know how tough these last few weeks have been for you all, exhausted as you are after the referendum campaign, so take some time out. We'll see each other again in 2 weeks' time, suitably relaxed and refreshed. I now close this meeting.